Kulikako, ke aku, aloha mai oi ka mea mua o, kalawale mai kumako, hewa ana me kumako, haumia me kumako, aiku, me kumako aya, me kumako waheva, me kumako hoiki ino ana ia oi. E maliu mai ola mai mako makikino, hele ku, hele kolo, hele ne e kolo pupua, hau make ole palalohala. Aola loa ka puani ani, kauola ia ke akua, pela ka waihako me ka waipa aku ia oi ke akua, pela ka ho mana ia oi. Umau ki ai mai ka po mai nana ia mai ka leo ka ko mai luna lalo mai kai ki mai kai ki na ke ko mahana mai ka uka e kai mai loko awahu kia ia malama ia pale ako ina ho pili ki ani ko ka ko no hona mama ua noa veli na me ke aloha ina ka ko ke ahi o au ne o kali ko ka eo e kumu no i wao ke maka mahele o Hawaii ka Hawaii studies oi makia kula nui nui ko mahalo ka po nane ho keli nei ke Papahana, Ashley Ma, nakaili ana mai keia po, ma Maui nei. Nui ko mahalo ka poi no molo kai ke kai kala mai alihiki ke ele mai keia po o Walter Ma, hele ana kala po. E na nui ko mako mahalo. No ka poi he nui loa ka poi hele mai keia po laulea, o ikaika, o olohe, o maupopo. Ho na o wau no hoi. No ke mea o ke aloha aina o ia no leila. Aloha. So again, on behalf of Hawaiian Studies here at our campus, myself, Kalikoa. Where's my boss? Kahele, right there, another faculty member. And I see Naone, Kumu Naone right here also. Mahalo to Kumu Naone. On behalf of Hawaiian Studies, we're very, very happy to help sponsor this event, this teaching. And I myself, I'm a big believer in education as an educator, and education for all, at all times. And I really appreciate Ashley here coming over from the Center for Food Security, and generously helping to organize this teaching. As we know, tomorrow we also have the main event. Yeah, this is just the poo-poos for the main event tomorrow. And I myself, I'm a big believer of home rule, and I think was it last week we had great Vandana Shiva who came to share and speak to us here at our campus, and it was a wonderful day for us who were fortunate enough to get her to come here and share with us. And home rule depends on being educated. The more we understand, the better we can decide for ourselves what is best for ourselves. And the key, of course, is that we need to get as much information as we can. And the key, of course, is that before, when you look at this issue of the moratorium, it's always been a very simple issue for me. If it's good, it'll be proven to be good. And if it's bad, it'll be proven to be bad. But the only way you're going to know things either being good or bad is you got to get the right diagnosis. So when you get the right diagnosis, it means you got to get all the information out there. And I know money confuses the information many times, and that's the truth. Being involved in many struggles as I've been in my life, I understand how money blurs up the situation. And so, and on the verge of tomorrow, this event tomorrow that we have, and hopefully as a united people, to showcase that in fact we are very upset with the mayor and the mayor's administration for not taking heed to the call of the people, not paying attention to the voices of the people, and not understanding that the welfare of our people in this land is the most number one concern. For me, I don't care about more jacuzzis and swimming pools and fancy houses on our hills. That's for a few. I'm concerned about our grandchildren and our great-great-grandchildren, that they have a place where they can live, clean waters, clean soil, and a healthy soil. As one of my great kupuna, Uncle Eddie taught me, or taught us, whenever you go someplace, you make sure you leave that place better than when you got there. So it's not about, guessing at the effects of things here, but I want to guarantee that the future of this land is better for the next generation than ours here. And so with that, on behalf of Hawaiian Studies, again, I'm very proud and happy that we were able to invite many important guests to kind of teach and share with us exactly what's going on. Because there's a lot of different ideas of what's going on out there. And before we make moves into this direction or that direction, it's always best to understand what are the options, what is the situation. And so, for myself, this teaching really is about information for the community. So, work with Ashley to bring forth certain voices that we can hear. And I know some of you might have some questions at this point. Some of you may have some concerns. But I ask you on behalf of Wine Studies that hopefully we're taking care at the end of this whole, this evening. Yeah, because we're really here to hear from those that we really need to hear from. Okay? And so I just ask that if you have any strong comments, that you kind of hold off on those comments so that we all can benefit perhaps at the end. And I'm going to turn it over to Ashley. Ashley's going to be the driver in this situation. But I'll let Mahalo on behalf of Wine Studies for coming this evening. Mahalo.
And I just want to mahalo you, Kalikoa. I think we need to start having new conversations and new places and new people and really diversifying the voices and ideas in our movement. And I think it's really important that we're all here learning together, because then we have a shared framework through which to explain to our community why these issues are important. I wanted to just take a minute and kind of mahalo the folks that are in this room tonight. For the core team that helped organize the moratorium, do you guys want to stand up and just let everybody, if you worked hard and made this a big part of your life, you want to stand up? Because you got us into this mess. We're going to just blame all of you for what's to come. Again, my name's Ashley. I'm from the Hawaii Center for Food Safety. And I'm not really going to say much. The point of tonight is to give you guys a really clear sense of what's happening with the litigation around the Maui moratorium, how that fits into the 3 litigations that are going on right now on these very issues, on Hawaii Island, on Kauai, and also in Jackson County, Oregon. How you guys are different, but also how some of these fundamental questions are being asked through community-based activism against large-scale agrochemical companies. So we're hoping that you get a sense of what's happening here, but also why it matters elsewhere, why Maui is under the spotlight around the world, and folks are really tuning in to what's happening here on your island. At the very end, as we said, tonight is the poo-poos for the main event tomorrow. If you're not aware, there is an action item. Do you want to say maybe 2 sentences about what's going down tomorrow morning?
2 sentences, 2 parts. The first part is we're going to welcome our officials to work tomorrow in a very peaceful but solid demonstration to kind of remind them who they work for. So that means we have to be there very early. 7:15 sharp. And part 2 is we are asking people to testify in the general county council meeting tomorrow, where the attorney, who is the guy that responded that they're not going to defend this moratorium, his job is to be reconfirmed tomorrow for the next term. Yeah. So we'll talk about that later. Lauren and Nomi have a really good presentation to talk about that a little bit, but that's part 2 that'll go on from tomorrow at 9 o'clock. So, cool. Yes, I'll get details for you before the meeting is over. I'm going to put them up here. Okay, thank you. Good question.
Cool. And again, we'll do questions at the end of the night. But so how the night's going to go is that the Shaka attorney is here, Mike Carroll, and Sharon Lim from Bays, Lung, Rose, and Olma. So they're going to talk a little bit about their work on the Maui moratorium. And then on Skype, we have George Kimbrell from the Center for Food Safety, who's going to be talking about how Maui fits into the multiple litigations that are happening here in Hawaii and nationally around regulating agrochemical practices in and around communities. For those of you who are really deep in on this issue, you know that Hawaii Island, what they passed and what they're defending is very different from what passed and what is being defended on Kauai. And those are both different from what passed and what's being defended here on Maui. So there are core questions that they share in common, but there are important differences. And again, we want to give you guys a way to understand that so that you can feel empowered. And as a political scientist, I'll just say one thing. I think as a community, you guys have flexed the purpose of democracy, which is to participate and make the rules whereby we live amongst one another. But when that gets taken into the courtroom, a lot of times we feel like we've lost our power, and we haven't. There's still so much that we can do as a community to hold these companies accountable. So hopefully in understanding the litigation today, you can start to sort of retake hold of your power and the role that you're going to continue to play in this fight. So without further ado, I want to invite Mike Carroll up, and he's going to talk a little bit about Maui.
Good evening, everyone. I want to thank everyone for coming out tonight. I am really fortunate to be able to work with the Shaka Movement on their case on Maui. Truly outstanding people, and it's been a privilege to go to work every day and talk to them. Again, I've been fortunate enough to be able to work with Shaka on the Maui ordinance. I was brought on to sort of help them through the process after the ordinance was passed. What we wanted to do after the law was passed, we knew that Monsanto was going to challenge the law. We knew that they were going to challenge the law in federal court. We knew that we were going to have a difficult time with the county, given their prior statements. We wanted to have the issues decided on the enforceability of the law be decided in Maui. We wanted a Maui judge to decide it. We felt that the issues in the case concern the provisions of the Hawaii Constitution dealing with environmental issues, environmental rights. So we went forward and we filed the first lawsuit a few days after the election results in state court in this town. The following day, Monsanto goes and files a lawsuit in federal court. So basically in mid-November, within days of the election, there were two cases pending. There was our case pending in state court, and there was the Monsanto action pending in federal court. That same day, the lawsuit was filed by Monsanto in federal court. Monsanto and the county entered into an agreement to basically delay going forward with the certifying the election results and delay implementing the law. So basically the votes was basically pulled away from under the rights of the voters were pulled away by an agreement between Monsanto and the county. We opposed that. We in response to that, we went forward and we filed a motion for preliminary injunction in our state court action. There's a statute under federal law that allows a defendant to remove a case to federal court. And what Monsanto did is they exercised that right to remove it to federal court for a basis that we believe is improper. The basis for federal court jurisdiction is there has to be a federal court question asserted in your action, and we did not assert a federal court claim. So we have filed a motion to bring that issue back to state court, and that's ultimately pending with the court. Also pending with the court is as part of the proceedings, Monsanto has filed what is called a motion for summary judgment. And that's basically a ruling on the merits to determine whether the law is valid or invalid. And we're going to be talking a little bit about the Hawaii ordinance and the Kauai ordinance. Those were both decided on as similar motions for summary judgment. And that's the same strategy that Monsanto has implemented in this case. And to back up initially, I do want to say is that the county has not been cooperative with us in supporting our efforts to defend the law. With respect to our lawsuit seeking the county to enforce the law, they filed a motion to dismiss. With respect to our efforts to try to remove this case to state court where we think it should be decided, they've opposed that. They have joined Monsanto and agreed with them that the case should be decided in federal court, which we believe is not appropriate. We believe that this should be decided in Hawaii court. In any event, Monsanto did file their motion for summary judgment. That motion is set for hearing in March, and we at the end of last month, I think it was last month now, right? the end of last month, we filed our opposition, and we were expecting the county to file their opposition as well. And rather than filing an opposition, they filed a one-paragraph statement of no position. We were obviously disappointed because we wanted the county to defend the law. We in no way encouraged them or made any statements that we wanted them to step aside. But in any event, the practical reality is they're relying on Shaka to defend the ordinance. And since I do have everyone's attention, I do want to just talk briefly about what the main issue in the case is with respect to it being enforceable and whether the federal court or the state court will actually implement it. And the issue really turns on a doctrine called federal and state preemption. And in general, it means that federal laws, if they address a particular area, federal laws will trump state laws. And if there is a state law that addresses a particular area, state law will trump county law. And we have that sort of hierarchy in place for reasons to avoid conflicts in laws, and so people understand the law to follow. What we are dealing with in Maui with respect to genetically modified crops and with respect to the activities that are happening is something that is unprecedented. The laws on the federal and state level do not address what the practices that are going on and what needs to be done. On the federal level, there's what is called a federal coordinated framework, which is 3 federal agencies that address different components of genetically modified crops, but they don't address the activities and the actions that are going on in Maui. On the state level, there's pesticide laws that require you to report pesticides and require to have certain license to carry pesticides. None of these laws on the federal or state level address the issues that our ordinance seeks to address, the issue that our moratorium seeks to require the testing and studies to be done. What our ordinance seeks to address is the specific practices that GMO operations are doing on Maui. And what the scientific studies have done, or what the scientists have studied and have looked at what is going on, is that basically Monsanto and other companies are using Maui and using Hawaii in a different way than other agricultural uses. They're using it as a testing facility to develop new strains of genetically modified crops. And one of these types of genetic modifications is developing crops to be highly resistant to increased uses of pesticides. And that, I think, in my mind, is the most serious aspect of the operations that I think needs to be addressed. And the operations involve using high quantities and combinations of pesticides that's greater than anywhere else in the country. And they do this without any studies, without any tests, without any determinations as to what the environmental impacts are. There's nothing on the federal government isn't looking at it, the state isn't looking at it, and it's up to Maui County to basically to protect their own land. And that's the function of home rule. And that's why this ordinance is so important. And it's not, in our papers, or excuse me, in Monsanto's papers, they refer to it as a ban. It is not a ban. It is a moratorium. It is a requirement that, just like any other activity that we require in the state that potentially might cause harm, there has to be some sort of standards, there has to be some sort of test followed before you go forward with the activities, not after the fact. And
it's already been proven to be very, very dangerous. It's actually an assault on the genetics of the human race. And it's a plan to
We're going to
solve.
walk moments for that. Thank you.
And the gentleman's comment is exactly right. And I would urge everyone to read our brief that we filed in the federal court, and we point to some of these studies that have linked these to severe environmental problems and severe health problems. But there has not been any studies done in Maui as to what these activities are doing. And that's the importance of this ordinance. And that's why I think what separates our ordinance from the other ordinances on Kauai, the other ordinance on Hawaii, is what we're asking for is that Monsanto, they make a lot of money developing these crops here, make them prove to us that it's safe before they continue the testing. Thank you.
Thank you.
briefing papers available to you guys. They are publicly posted. And as somebody who's read them multiple times, it's just a thrilling read. So now we're going to turn it, we're going to wait till questions to the end, just because we want to get through.
Misselman, I'm an attorney. I have two very pointed questions.
We will take care of them at the end.
Okay.
So we're going to turn it over now to George Kimbrell, who's the senior attorney at Center for Food Safety, who Center for Food Safety, along with Earth Justice, has been litigating against these chemical companies for almost 2 decades. And so they'll give us the broader context within which this case makes sense. Is everything okay? Can you hear, George?
I can hear. Can you hear me?
I can hear you.
Good evening. Thank you all for joining us tonight. I want to echo the thanks that was given earlier, and thanks for your efforts in advance tomorrow. Wish I personally could be there with you, but I'm glad that it's happening and happy to help any way I can tonight here remotely. So let me know if you can't hear me. As Ashley said, I'm George Kimbrell. I'm one of our attorneys at Center for Food Safety. I've been litigating against Monsanto and other chemical companies about the impacts of genetically engineered crops for over a decade personally. We have been working on all 3 of the Hawaii cases now for since the ordinances were enacted, but then since the litigation has begun over a year now, pretty much nonstop. So I guess I'll start by just adding my 2 cents about the Maui case. I thought Mike did a great job giving an overview. The rest of the story from our perspective is, we also try to intervene in the case, the federal case, in order to defend the ordinance on behalf of our own organization, Center for Food Safety, as well as a local organization, Moms on a Mission, Moms Hui, and then some local farmers. And the court basically said, well, we're not going to grant you the ability to intervene because we're already going to let Shaka intervene in the case, so you can file, a shorter brief in support of the ordinance, but that's all. And so that, I think, looks a lot more ironic now in light of what happened last Friday with regards to, the county refusing to defend the ordinance at all, leaving Shaka's brief really the only one of length out there, along with our shorter brief to defend the ordinance. So quite bad form, I think, unethical conduct in many ways by the attorneys for the county there. So I'm very glad we're doing this event. But yeah, I think the legal issues that encompass all 3 cases have to do with preemption, as Mike said, both federal and state, and they have to do with the regulation of genetically engineered crops. And long story short, for 2 decades, we've had a failure to lead at a federal level when it comes to these activities. Washington, D.C. has not properly, provided any protection to the environment or human health, or done a good job overseeing them, or really even analyzing their impacts on health or the environment. Most of the agency's oversight is voluntary, and that is not voluntary is barely cabined to specific types of impacts that don't really encompass the types that we care about, such as transgenic contamination of organic or conventional farmers or wild plants, or pesticidal impacts, from the really significant pesticide uses that come along with genetically engineered crops that have been discussed. So because of that, what's happened is us at Center for Food Safety across the country, we've seen people reaching out and saying, we'd like to address this at a grassroots level. Can you help us draft ordinances or state laws, whether it be for labeling or for better responsible regulation? And that's been very encouraging. And we've been able to do that in a number of counties, almost a dozen across the country, including the 3 recent ordinances there in Hawaii. Now, as Ashley mentioned, they're all slightly different, but again, I think they are of paramount importance nationally because of the unique ecosystem environment that Hawaii provides, as well as the fact that it is the epicenter of genetically engineered crop production and seed development for these chemical companies. So it is ground zero, so to speak, in this larger struggle for all of us. The Kauai ordinance, which was Bill 22491 that became Ordinance 960, that the Syngenta and the other chemical companies sued in January of this year over that ordinance. It's an ordinance about buffer zones and transparency, about disclosure, about what you're spraying. It has a section that deals with genetically engineered crop disclosure, but it's mostly focused on pesticide disclosure and pesticide buffer zones around sensitive areas like schools, waterways, and hospitals and things like that. So in that case, we did intervene on behalf of our own organization on behalf of Surfrider, Pesticide Action Network, and a local group of citizens on the west side of the island directly affected by the spraying. We did help defend the law all through March until August, in which the judge in that case, Judge Curran, the federal judge that was assigned to it, ruled in favor of the plaintiffs on state preemption grounds, basically saying that even though Hawaii state law did not say in anywhere written that counties could not regulate this activity, he nonetheless found that such activity, the counties were prohibited from regulating it implicitly or by implication by the current scheme and intent of the state pesticide laws. And he found the same thing for genetically engineered crop oversight when it came to seed certification laws in about a paragraph. So that was a disappointing decision, very disappointing, I think wrongly decided on state law grounds. On federal law grounds, he said that states and counties could take action because, as Mike said, and as I alluded to, at the federal level, there really is an absence to lead when it comes to any type of law addressing these impacts. Even the coordinated framework that Mike mentioned is not really a law or even a regulation. It's an executive branch policy from the 1980s that really has no teeth. So he found in our favor on federal grounds. So that decision is now on appeal. It's the lead case, and it's already gone to the Ninth Circuit Court of Appeals, which is the federal court of appeals over Hawaii and all of the western United States. And we filed our opening brief along with the county in that case in January of this year, last month. So that's kind of in time the lead of these cases. The next case, the other case that's going on, as you know, is the Big Island case. That's Ordinance 13-121. And this is a different type of an ordinance than both of the others slightly. It is focused more on genetically engineered crop production. It's a prospective ordinance as drafted that would grandfather in existing papaya growth there on the island, but prohibit further development by the chemical companies because unlike the papayas, the vast majority of genetically engineered crops are these herbicide-resistant, pesticide-resistant varieties, and they come with a tremendous amount of pesticide use that comes with them. So that was the intent of that ordinance. And again, the same law firms there, hired by chemical companies and some local folks, sued the county over that. We again moved to intervene on behalf of Center for Food Safety to defend the ordinance, as well as local farmers there on the island. And in that case, the court, the same judge, same federal judge, again ruled on state grounds, pretty much following his earlier ruling. That case went from March until September or October. We had the summary judgment argument in October of this past year in that case. And so Judge Curran again said, well, even though the state law nowhere says that counties can't regulate this activity, I'm going to find that it implies that they can't regulate it, because of the scheme of existing laws over this, none of which, by the way, even mention genetically engineered crops or seeds or organisms at all, let alone say anything about whether counties can regulate them or not, or how they might be able to, or how they might not be able to. So that case is also on appeal. In that case, Judge Curran denied our motion to intervene, limiting us to amici status, which meant we did not have the right to appeal it. So it was very important that the county itself appealed it, which they did. Unlike the Maui county officials, the Big Island officials, as well as the Kauai litigators, vigorously defended those laws in a way that was ultimately unsuccessful to this point, but they did try, is what I'm saying. And so last night, I'm happy to say, the county council there on the Big Island voted to bring on myself and our colleagues at Earth Justice to help them with the appeal directly to the Ninth Circuit. So we will represent that county directly in the appeal of that decision later this year. So that's very good news. It will allow us to work directly with the county and represent them and hopefully get a better decision. Thank you. And yeah, I mean, I think the ability to do that was in large part because the people of that island went to that meeting yesterday and really spoke loudly to their representatives about how important it was that the county allow us to represent them. And it prevailed. So I think it was a powerful sentiment of public democracy. So that's a very brief overview. I want to get to questions. I know it's late there. Like Ashley said, there's a lot of papers. We've killed a lot of trees, unfortunately, in these cases, doing our best to defend the ordinances. I recommend you read all of them, especially if you have a hard time sleeping. I'll stop there.
Well, thanks, George.
right, or not?
It's okay.
Okay.
It's okay.
Okay.
So we know about Maui. We now know about the sort of statewide framework nationally. We're going to take it back to Mike for just 5 minutes. He's going to talk a little bit about sort of, again, how the Maui case is a little different and how it fits into maybe a different strategy for your island. After that, we're going to take a brief pause for questions just on the litigation. As we said, tomorrow is the main event, and so what we wanted to do while we had everybody here is talk a little bit about participating in the testimony process. And some of the wonderful women who work hard here on Maui have prepared a short presentation for you guys on how to give great testimony. So if you're wondering how to testify effectively in the county council meeting, it's going to take 5 to 7 minutes, yeah? I also wanted to note that on the buffer zones and disclosure question, just today in the House Energy and Environmental Committee, the committee unanimously passed a bill which would create a statewide framework for buffer zones and disclosure for the entire state. The bill in the past has never gotten a hearing. Today, committee members sat for an hour, 2.5 hours, listening to testimony from people from Molokai, people from Oahu, people from Kauai. So it was a really powerful, powerful event, and I would really encourage you guys to take the testimony talking points and leverage that at the state too, because we really need your mana'o.
Is that 1514?
Yeah, House Bill 1514, and then there's going to be a Senate bill that will be heard soon. So stay tuned for that hearing announcement. So without further ado, I'd like to bring Mike back up, and he's going to take us back to Maui and your litigation, and then you'll have time for your questions.
Okay. I guess the purpose of my explanation now is to sort of explain what makes the Maui ordinance different from Kauai and the Big Island. And before we had this evening, I was fortunate enough to sit down with Bruce Douglas, who was the original drafter, whose vision this ordinance was. And what I gathered from our discussion is that this vision that he had, and hopefully that will be law and be enforced, is something different that from the Big Island and different from Kauai. And he got to look at those as examples and find a way that can improve on it and find a way to make a good law that addresses what the real concern is. And I think he did an outstanding job in doing that, and I'm hopeful that when we get to court, the court is going to see that, and when we get to the opportunity to enforce it, I hope it gets enforced. Talking about some of the differences between the three laws. In Hawaii, the Hawaii law that was adopted on Hawaii was basically a ban on open-air testing for genetically modified crops, with the exception of papayas, because the papayas were basically widely genetically modified due to the ring spot virus. So that was so whereas the Hawaii law was a complete ban, there wasn't a requirement for testing, there wasn't a basis to lift the ban. The Maui ordinance is a moratorium that requires basically testing be conducted before these activities are completed. The Kauai ordinance is very different from either Hawaii or Maui. And basically, the Kauai ordinance sets forth pesticide reporting requirements, buffer zones, disclosure requirements. It really is not a genetically modified ordinance law. It addresses these other sort of corollary issues to it. The last thing I think that is a really important distinction between this ordinance and and Kauai and Hawaii is that this is a voter initiative, and this is an ordinance that wasn't drafted by legislators. It was drafted by ordinary people, and extraordinary people. And it wasn't something that was approved by a city council. It was something that was approved by voters who stepped forward. And while it's unclear what the stance is in the law when that happens, in my mind, I think that makes this law significantly more powerful, and hopefully that is what is going to set us apart.
I have the dubious honor on on a regular basis of moderating Q&A. I've been a professor for 10 years, so try me. I can be pretty harsh. We are here to ask questions. It is very rare when we have experts in our room. So we're not here to soapbox. We're here to ask and sort of mine them for the knowledge that we need to feel informed and empowered. And I really want to encourage that kind of conversation moving forward. We're going to give it maybe 15 minutes. And so maybe say your name and what ahupua'a or what area of the island you live in, and then short question. Again, we're here to ask Mike and George. Okay, so.
My name is Francis Ballard. I'm 30 years on the island. Francis Ballard from Wailuku. I got a simple question. In Honolulu Civil, Ron Antone, the mouthpiece for the mayor, stated that they were prepared to enforce the law if the feds decide. I'd like to know what's their backup plan. Do you know anything about that?
To the backup plan in terms of what?
To enforce. To enforce if the feds come through with a decision to in fact enforce.
We've been trying to get that information.
Could you repeat the question? We couldn't hear it.
Okay, so the question is, Rod Antone said that the county was prepared to enforce the moratorium pending the litigation decision. How do we know?
Well, to answer your question, we do not know at this point. And one of the reasons why we filed our lawsuit was to make sure that they actually did enforce it. We are in the process of requesting information from the county. I think at this point they are basically deferring anything until the court rules. And realistically, I think we're going to have to push their hand, or hopefully a light nudge in the direction of enforcement if we get a good ruling.
Cool, mahalo. Next question, let's go over here. Anybody over here? Yes, OG guy. Name, part of the island?
My name is Jack Breen. I live in Wailuku. I practiced law for about 35 years, about 25 in Hawaii.
Great.
Had a lot of injunction background stuff. So I have a couple questions I want to ask. They're kind of technical.
So let's go with your first question.
One kind of technical question is, have you been able to put into the record in some way the uniqueness of the activities of the Monsanto and Agrigent? Because they got summary judgment before any discovery, right? The motion for summary judgment was filed before discovery?
That's correct. And what we filed basically a 60-page memorandum in opposition. And I hate to pat myself on the back, but I think we did a good job in laying out the factual reasons why. And we have testimony from affidavits from witnesses that testify to the harmful effects, the environmental issues, and what makes the practices different. And we also are, you're familiar with 56F, which is a opposition to a motion for summary judgment that says we need to have discovery, we need to get
good. Okay, yeah, that was my thought. I was just wondering, did you try to just jam it in with affidavits, and wouldn't you rather have some discovery?
We've asked for that one.
Okay, and are you seeking certification from the Hawaii Supreme Court of the state law issues and the other?
Yes, we are. We've asked for that as well.
And
last one.
Last one, and I swear.
Okay.
I thought I heard you say uniqueness is the main issue as you see it to get it out of a perfect preemption situation. There has to be something unique that allows the county to be having laws that regulate this. And so is impact the primary uniqueness that you have?
It certainly is the main one in my mind, anyways.
Okay.
There's a lot of different points that we've laid out in our 66 pages that I don't think this room would be too interested in hearing.
I read the complaint, but I haven't seen your filings. They're not easy to
it's
find.
available on Shaka's webpage.
The filings are on the new website, Maui GMO, Maui News, Moratorium.org.
Great.
All the filings are there for you.
Great.
Thank you.
Good
So
question.
everybody got that website, GMO.
It's on this sheet too.
Put it on the board.
Okay, we'll write it down. All right, next question. Yes, in the blue.
I have a question on the usurpation of the local state rights. Obviously, this is generally run by an oligarchy of criminal activity that's putting like the chemicals on the people, and they'd like to take it to the federal level. I'm wondering, this suit, is this more about how dare you local people create a law and try to enforce it against the corporate federal government? Are they going to try to preempt it into the national level with the judge's bot, or and say that the whole referendum was basically illegal? Is that what they're trying to do, or are they going to try to fight the merits of chemical poisoning of the people?
It's a really good question. Okay, I'm just going to repeat. Did everybody hear the question?
No.
So what's the basis? Are they fighting on whether or not chemicals are safe? Or is the question in the litigation something different?
Say there's something different, so poetically, the way you explained it.
Poetically. Right.
The argument, they're not talking about whether it's safe or not. And they make points, they make conclusory statements that it's safe, the federal government's approved it, it's got to be safe. But they're not, that's not the point of their argument. Their point of their argument is saying it's a conflict between federal law and home rule. And their point is saying, Maui County, you don't have the right to check these things. Even though the federal government doesn't do it, the federal government law trumps, and they have exclusive rights to do this. And if they don't want to do it, tough Maui. And I think your point is correct, and I think that's they're avoiding that argument because I think they would lose it.
George, is there anything you want to add on like the fundamental basis of their argument versus the merits of the technology or its safety?
No, I mean, I agree that the cases are not rising and falling. They don't want to get into a debate over the impacts. They don't want to have discovery. You know, they want to have it be these clean legal issues where they can argue preemption or constitutionality, and that's what they've been able to do to this point. You know, I think that from their perspective, you know, they do like the facade of oversight that currently is present at the federal level. They would be hamstrung, I think, by the absence of any oversight. But at the same token, that's not what the cases have been about to this point in any event. They've been about these legal questions about what counties can or cannot do, you know, under existing law.
And I will say that in Curran's decision on the Kauai case, the first thing that he said is this decision does not take away from the health concerns of the people of Kauai. So he very clearly placed those outside of what he was considering in his brief. So we need to remember that. Can we go outside maybe?
Joseph Cohen, Wailuku. What legal recourse do we have against our elected public servants if they refuse to comply with our mandate?
Recall election.
So the question was, what recourse do we have as the people for holding our elected officials accountable for not enforcing the moratorium that we, the people, passed? Are you an elections attorney?
That's a good question, actually. It's a tough one for me to answer on the spot here.
Welcome to our teaching.
Sue the bastards.
Yeah.
Well, you said they were unethical.
Hold them personally responsible.
Great. Yeah. Okay, so I think what Mike is very delicately trying to say is that he's not willing to go on record and give legal advice to this room, which is fair. Let's remember, everybody's in a different situation with this.
Okay, so off the record.
Okay. Okay, yeah, no, unfortunately the camera is the record. Somebody over here, Joe, you wanna?
Sure, I'm Joe Ritter, I'm from PA. I'll make a very quick question, it's again about federal and state preemption. So if we win in March, or if the people win in March, and if the right to farm bill passes, will that undo everything? Will the state then preempt this even if we have won in court?
Great.
Yes.
And if so, that means something about what we need to do for lobbying the state.
Okay. So the question was, if we win in March, but the state legislature passes what is now House Bill 849, will it undo everything that we've done? And George provided his answer of yes, yes, but...
I will provide a lawyer's answer that I think it's unclear as to the effect of it. I definitely think that bill is a bad ordinance, and I think it restricts home rule. I think it restricts counties' abilities. I think there's issues that are still yet to be decided. We don't know what the final language of that bill is going to say. Assuming it does get adopted, we don't know whether that the legislature intends it to have any retroactive effect, where it's intended to apply to ordinance that have already been adopted and in place. We don't know if there's constitutional impacts as to whether the state legislature can constitutionally create laws after the fact when Maui electorates have already voted. I think it's unclear.
Great. Do you want to say anything on right to farm?
I agree with Mike. The short answer though is we can't let it pass.
Right. So there was a hearing today on this bill, the Right to Farm Bill, HB 849, and despite overwhelming opposition from in-person testifiers, the committee did pass the bill. So what do you do now? One, you feel a little bit better because the chair of agriculture in the Senate, Russell Ruderman, has said loud and clear he will not pass a home rule bill. Yeah. And you can't have one bill go out of the House and not go out of the Senate. It's got to go through both. However, you need to hold your elected officials accountable, and Woodson from Maui did vote to pass the bill. So the most scary call is from a constituent. You asked, what recourse do you have? Unfortunately, I'm going to send you right back where you started and vote. Or run. Or find somebody to run.
Yeah.
So next question.
Right.
Why don't we get a lady? Why don't we get a lady up in this? A woman. Yes.
Hi, Debbie Maynard from Kihei. In the case, they did not certify the election, correct? Or did they just not certify the moratorium?
They have not certified the election. The results would be the technical.
So how can our elected officials be acting if the results were never certified?
Hey.
They're not certified. I think they're selectively not certified. They're not certifying the election results on the moratorium, but they're certifying the other elections.
Their own. They did a partial.
Anybody come over here have a question?
I do.
Yes.
Yeah, I heard on the radio that there was already an extant law at the state level that indicated that any laws pertaining to agriculture would be passed on the state level. And I was just wondering if you were aware of any such laws at the state level that would put specifically agricultural laws passed by the county, or if there were any county laws regarding agriculture already in existence that would kind of prove that law didn't exist, or I was just wondering if that was true or if that was disinformation.
The state preemption arguments is really the main focus of the case. We dedicate maybe about 30 pages in our brief. I think Monsanto dedicates about 50 pages. There is, to answer your question, the short answer would be no. There's no law that says the agricultural laws are restricted to the state. And look at zoning laws, look at nuisance laws. There are requirements for it, and it's not a clear-cut issue, and that's the issue that's going to be resolved. And there's a lot of gray, and our job is to make that gray a little more black and white for the court.
Thank you.
George, do you have anything you want to add? Are there laws on the books that already tell us how to proceed?
No, I mean, I think, like I said earlier, there's nothing that speaks to this subject matter, which is one of the first prerequisites about these questions about what counties can or cannot do under state law or under federal law. And so, that should be the first thing the courts look to. With regards to agriculture specifically, even in the Kauai decision, in which Judge Curran eventually found pesticide laws implicitly preempted, Ordinance 960, he did say that counties could regulate some forms of agriculture, like zoning, like Mike was saying, and other forms. So it's not an all or nothing proposition, and so it's really a matter of interpretation that I think is, open to question. And of course, one thing that we haven't noted that's important is that, as Mike said, here in the Maui case, we have not only the state court action, Shaka's action, that's a different venue potentially, hopefully, and as well as a different judge in federal court than we did in the other two cases. So it's possible that, she will have a different opinion about some of these questions than the district judge from the earlier two cases. So.
Great, thanks, George.
Thank you.
In the back in the Navy.
Yeah, Gary Dameron from Go Green Culture Foundation. Is there any basis in law or any precedent that would allow us as citizens to enforce a recall election for our officials who are not representing us?
Repeat the question.
Can I pause it really quick and just say that let's remember that attorneys have different areas of expertise, and I'm going to speak on your behalf and say that Mike is not an elections attorney. So if we have questions about elections, then we got to hold those. And you know what? I think you have a really great community organization, Shaka, that's been, you know, helping everybody navigate through this. And so maybe they can collect those questions and we can try to figure that out. But right now, let's not ask Mike elections questions, because I think we're going to get the same awkward feeling like I'm not going to go.
Has it ever happened?
That being said.
Has it ever happened?
Here.
Autumn.
I'm just going to give you the 30-second answer. I'm not an attorney. I am not an elections expert. I do, however, know that a lot of people have been bringing up the recall thing, and I, for one, am going to tell you, I don't think it's possible, only because we know how low the voter turnout is, right? In order for a recall election to even work, half of the registered voters have to turn up to vote. Let me say that again. Half of people who are registered to vote need to vote. Do you know how many people actually voted in the last election when it was that contentious?
32%.
It was like 40-something percent, I think. 32%. That was, do you see all the whining and bitching that happened on for the last election? 30-something percent of people turned up to vote. So everyone is asking me daily about a recall. I don't think it's going to happen. So we need to find other avenues that are more, you know, reasonable. You know, I think. Anyway,
the recall process is detailed in the county charter.
Yeah, great. Thank you.
It's really hard.
Okay, in the maroon.
Oh, thank you. Brian Lehman from Wailuku. Should the county have made their position clear back when all the parties were, when all the motions to intervene were being heard? And given their position of no position, do they have an obligation to hire outside counsel?
Did you hear the question?
Repeat it again.
Yeah.
Okay, great. So because the county, given the county's participation in the motion to intervene, should they have let us know that they weren't going to do anything? Would that have changed the game? Because we had a hearing whereby Shaka made arguments why they should enter the case, CFS made arguments why they should enter the case, and the county weighed in, because the lawsuit's between the chemical companies and the county, right? So should they have let us know that they weren't going to do anything at that time?
I think if they would have said that they were not going to take a position on it, I think CFS would have been a party to the case. I think they wouldn't have been denied intervention status. Would we have done anything different? No, we wouldn't have done anything different. We would put the same amount of effort into it as we did. Does this change the results as to what's going to happen? I don't think. I think that's undecided at this point. I don't think that's a material issue, whether they're defending it or not. I strongly believe that the ordinance needs to be passed, and I think we did an outstanding job briefing it, and I think the county would have done better.
Should they hire outside help?
I think they should have. I definitely think they should have, and obviously they didn't want to spend any money on it, and they didn't, unlike what they did on.
But aren't they obligated?
I would say that's part of the reasons for our lawsuit against them to enforce the ordinance.
I'd like to give 2 cents worth on it. You know, I would say, you know, you can have there's quite a juxtaposition, I guess I would say, between the way Kauai handled that case versus what's happened now in Maui. You know, as I said earlier, what happened in the Kauai matter, as most of you will likely know, the mayor, you know, was opposed to that ordinance and vetoed it. They overrode his veto, but because of that, during the veto process, he released his own attorney's opinion about the law, which was adverse to it, saying it had a lot of problems. And that conflicted those attorneys, the county's attorneys, out of that case, requiring them to go out and find somebody to represent the county in the litigation early on. This is before the lawsuit, once the lawsuit was initially filed by the chemical company, so before intervention, before the merits, summary judgment, all of those things. So it happened earlier in the process. And, they did go out and find a firm that did represent the county at some cost to the county, and did, I thought, a pretty good job with the briefing on behalf of the county. So that was, you can compare that to what happened with Maui, where, again, you had obviously some adverse views to the ordinance by the county officials. It manifested itself in a different way, obviously being a ballot initiative versus being a legislatively enacted ordinance. But I think it's kind of a distinction without a difference. The only problem was, here, we were all, at least Mike and I was under the impression that they were at a minimum going to file an opposition brief. After all, they had agreed to this briefing schedule. They had stipulated to a delay of the enforcement, but that's a lot different than just capitulating completely and taking no position on the merits of the briefing. I agree with Mike, had they opened that position earlier, the court would have brought us into the case along with Shaka. I do think that that's true. Whether it will make a difference, I guess time will tell, but certainly they need to be held accountable for that. And I think the question number one that you should have for them in any hearing that you can do, including tomorrow, is why did you do this? Give us your rationale for doing this, because as of right now, it remains undisclosed, at least as far as I know, exactly what their position is about what is their legal rationale for refusing to defend a lawfully enacted ordinance.
Yeah. We're a little bit out of time. We want to open up the floor to our ladies to talk a little bit about giving good testimony. So I'm going to create space for 2 more questions. I want you to ask yourself, is my question the question that has yet to be asked, okay? Yes.
This is for George. The DARK Act, how is that going to influence everything that we're working on here?
Yeah.
That's the Pompeo bill at the federal level in Washington, D.C. For those of you that don't know, it's called the Deny Americans Their Right to Know Act, or the DARK Act is the acronym, aptly put. So it's about labeling and whether states have the power. It basically is very, very much like a state preemption bill, except on a federal level, and except about labeling and whether states can require labeling. So Vermont, where we're litigating now, where we got a law passed, other states like Connecticut and Maine, where we've gotten laws passed. We have a bill there in Hawaii that was requiring labeling. Here in Oregon, where we had the ballot initiative the last time around, where we lost by 800 votes. All of those would be preempted if the DARK Act passes, so it's very important for transparency, for labeling, which of course is a type of regulation. If you have labeling, you know where impacts are. Very important for following that for causation legally. We have to stop the DARK Act.
Great. And final question, gentleman in the red.
Why can't, Ed Feline from Kihei, why can't we file a writ of mandamus with the district court compelling the county to support this lawsuit, compelling them to obey the law? I mean, a writ of mandamus would force them to do that, wouldn't it?
We looked at, when we filed our complaint, we looked at filing a writ of mandamus. We looked at other options. And the way that we came out is we thought the appropriate or the best way to address it was to file a circuit court action in state court where we asked for injunctive relief, which is similar to mandamus. And you have the option of filing for preliminary injunction, which we did. And that, unfortunately, right now is in abeyance because of the pending maneuvering that's going on. But we do have a pending motion for preliminary injunction, which is essentially the equivalent of a mandamus that you're suggesting, if that answers your question.
Great.
Thank you.
So let's give our attorneys, George and Mike, I studied social movements during my doctoral process, and one of the things that you learn when you read about social movements all across the world is that you need many talents, and the earth and our islands need a good lawyer. So we're really mahalo, both of you guys, for writing a lot of really boring briefs. So now I'm going to turn it over to Lauren Rigo and Ms. Nomi Carmona from Babes Against Biotech. They're going to give you guys a short 8-minute sort of toolkit for tomorrow when you testify against the reappointment of your county council, county attorney. County attorney.
Yeah, let's have Autumn from Maui United, who was amazing in canvassing on this moratorium. She's just going to do like a minute overview of what's going to happen tomorrow, and then we'll give you some tips on testifying for effective advocacy. So, big hand for Autumn next.
I'm really excited to see you guys all here, because I just thank you very much for coming and sitting through this. This is amazing.
Thank you.
Two things. I'm getting a lot of question marks over the head looks, and some people asking me what does this buffer zone, what does the right to farm bill mean? And I'm getting all these alerts in my inbox to make phone calls to committees that I don't even know what's going on. You know what I mean? So a quick reminder: until November, we were a bunch of hippies screaming about crazy stuff going on in our island nobody believed in, right? November?
No, we're not.
No. I mean, I'm talking about like to the powers that be. You know what I mean?
Yeah.
Right. Now, as of November, we are a voting bloc.
Yeah.
Woo! Do you understand what that means? That means we have this incredible power that we need to wield on a daily basis right now. Legislative session is only how many months long?
3.
3 months long. Right now, as we speak, for the next 3 months in Honolulu, decisions are being made that affect us and the laws we just passed in our future. So that's why you're getting this barrage of stuff in your Facebook and in your inbox, and it's a little bit confusing. Bills go through a bunch of committees, and then they go to the whole of the House or the Senate for a vote, right? You have a chance each time it's in front of a committee to log your support or opposition. It's really, really easy. There's a link to the website of the state. Give yourself 20 minutes the first time you open it up. It's like anything, it's like Facebook. The first time you open Facebook, you were like, what does this mean? How do I load a picture, right? And now you can do it while you're sleeping. So open the Hawaii State Ledge website. You have to log your name. We'll send you bill numbers that come HB or SB or whatever, and there's a number. You just put it in the search box, search it. You literally don't even have to write testimony if you don't have time. If you're busy, if you've got 10 minutes and you need to get to work, all you gotta do is hit support or a post and send. If you have time, please write why you're doing that. But a lot of times, sorry, I have to do this. A lot of times they just want to know how many numbers of their constituents are in support or in opposition. So do it. And then once you do it the first time, I literally testified, logged my support or opposition on like 14 bills yesterday in probably under 10 minutes.
You don't need to be a voter.
And you don't need to be a voter. If you are, it's more important. And if you do live in somebody's area, it's better to say that. But if you don't, just put your stuff down there.
Great.
Okay,
So 1 minute on tomorrow.
Yeah, tomorrow we're going to show up. If you can be there at 7:15 sharp, please come and meet on the front lawn. I won't get into details about what we're doing for a reason. It's very peaceful. It's all legal, and it's meant to give a firm showing that our elected officials cannot make decisions that go against us and not have to look us in the face.
Yeah.
We all live in a small island. They need to be able to look at the people that they're affecting and not just sit in their comfy offices and get away with whatever they're getting away with. Then these two intelligent, wonderful ladies are going to talk to you about what's going on after 9. Like I said, the attorney that is chosen not to enforce the moratorium, his job is up for...
His name.
His name is Patrick Wong.
Can I make one point?
Yeah.
You can be standing outside the front doors and so on, and everybody parks downstairs and comes.
Yes, we know.
Thank you.
Okay, so, anyway, so if you can testify tomorrow, please come. These ladies will tell you how. Take it away.
Thank you so much, Autumn.
Sorry, it's a question. People that can't go tomorrow and want to testify, we need they want to email testimony.
Technically, it should have been in today by noon.
But
you could drop off 12 copies.
You can drop off written copies. We'll cover that on our social media. We'll ask everyone to help get it out tonight so that you can have links to go to. But generally speaking, yes, you can email testimony, but do please come tomorrow.
If you go to like the county website, sorry, it's a question. If you go to the county website, there should be an email for general, tomorrow is a general county council meeting. There should be one email that goes to all of the council members. It's really easy to find, just go to the Maui County website or do a search on county council email and send one email out to them tonight. And it's better than nothing.
Okay, so real quick, let's go over, my name's Naomi Carmona, and I'm a representative for Babes Against Biotech. Lauren Rego is our Maui coordinator, and we worked very hard organizing the canvassing and phone banking for the moratorium. So if you do choose to come and share your mana'o tomorrow on whether or not Patrick Long should be confirmed, we're just going to go over some quick tips of things that we've learned over the years organizing in the community and testifying. So, Lauren, you want to pull out your notes?
All right. So the first thing is we want to be prepared. We have 3 minutes to talk. It's a really short time. Can you speak up? Yep. So you want to make sure that you write your testimony in advance. So tonight, write it out. A lot of times what happens with me is I write it out. When I read it, it's double the allotment of time. So you want to write it out, even if you don't plan on reading it. It's always better to be prepared than to just wing it up there. Okay? You want to make sure you have a clear message. Practice it at home, read it out a few times. You can time it. I use a stopwatch feature on my phone all the time. It's never 3 minutes the first time through. So it's really beneficial to practice it. So as a rule, council meetings, you have 3 minutes to talk. You're allowed to ask for 1 additional minute, but they don't always grant that to you.
They won't.
Okay. So practice it at home, prepare. You want to be able to, speak it clearly, speak it fairly slowly, so that everyone understands. Now, repetition is okay. What I mean by that is that it's all right if your testimony mirrors exactly what the person before you's testimony was. That's the strategy of the seed companies. They send people up one after another saying the same thing. My job, I love my job. So it's perfectly okay if your testimony is very simple and is the same testimony as the person before you.
That's because they only have one argument.
Don't pack up and go home because your message was already delivered by somebody else.
Right, so the repetition's okay, but obviously you don't want to be redundant in your testimony. You want to respect the council's time and move on as quickly as possible. Be respectful. So address the council. State your name for the record. If you have what item you're providing testimony for, I believe it's 15.5 is the communication. Make eye contact with the council. Stick to the time limit. They do not like it if you go over the time limit. Follow the rules of conduct. That means that if you have to make direct remarks, you make it to the chair and the presiding officer, not to any individual council member or anyone in the audience. Be friendly, and all of these things show respect for the council by respecting the process. So we'll get a little bit closer to trying to get our council to enforce our will. Let's see. Do you have any specific qualifications? State those up front so that the council knows with what authority you're speaking. State where you're from so they know if you're in their district. And you want to be dynamic and provide a really strong testimony to the best of your ability without getting emotional. Sometimes when they hear emotion, they just shut down and they think that your argument is pure emotion. So we want to make sure that we are dressed for the occasion, dressed appropriately and professionally, so that unfortunately sometimes people need to see you as someone that they should listen to. So we just want to try to appeal to our council members who are used to getting lobbied with money and golf by wealthy lobbyists who donate to their campaign funds. So, and then be factual. Make sure that if your testimony should be compiled of evidence and facts. And you're going to need to be able to back that up. So if you're putting facts into your testimony, make sure you have a solid resource that can back that up. Ideally, you have time to put the link in there and send that to the council members. So, make sure if you're talking about GMOs, you know what you're actually talking about. Unfortunately, it's there's a lot of information out there, and you need to make sure that you have good, strong, credible resources. There's a ton of information on CFS website, on PANA's website, and if you need help, please come talk to us.
There is no GMO broccoli.
Right. We had that on one occasion, and there is no GMO broccoli, and this person was talking about how they can't forget the first time they ate GMO broccoli, right? So that makes you lose your credibility. You say one thing that's not correct, and you may lose your credibility with the whole council. Can I take this one?
Yep. So we want to make sure tomorrow when we're in the building that we're polite and on our best behavior. So let's just use some common sense. The actions of a single person will reflect on the whole. Okay, so that means in the elevator, in the hallways, when we're sitting in the audience at the meeting, there's no really clapping, yelling out, booing. It's not okay. In the parking lot, for example, like let's please respect these guys. Let's not park in their parking spaces, as has happened before.
You have to say these things.
Okay. Also, if there's a long list to sign up for testimony, you get in that line when you get in that line. So no jumping the line. In long meetings, often they jump back and forth to Hana, to Molokai, to Lanai. If you caught a person in line, sometimes you're pushing them back an hour in their day. So we learned it in kindergarten or something. We're all adults. Get in line when you get there. No cutting.
It's very simple. Just follow all the rules that you learned in kindergarten. It's not. Unfortunately, feel we have to reiterate. But yes.
Are you guys going to provide information for the group about Wong specifically so that we have data on him? Because the hearing is about him, it's not on GMO.
Right. That's true. So I think just really briefly, Patrick Wong is the lead counsel right now for Corporation Counsel. So he's responsible for filing that no position brief. And there are a couple of other things that he's done. I think we can probably just mention them really briefly. But I think we don't want to just come in and villainize him because of just the GMO issue. So try to do your research on these couple things that Lauren's going to mention and look, why is he not an appropriate attorney to represent Maui County in other ways than just the GMO moratorium issue.
Has he been contributed money by Monsanto to his?
We'd have to look at that, but I doubt it. I mean, who knows? We can't see anything on the books right now, but that's not.
It's hard because so much of it is tied up in legal documents, which are either still active and you can't see it.
He's not elected, he's appointed, so he doesn't have a campaign coffer to get donations.
As far as funding, yeah.
So a couple points.
One thing I've spent the last 3 days literally just looking on stuff with Patrick Wong. There are people in the community that want to see him held to the fire, but it's very hard to find anybody who can give you something specific, being that it's all about lawsuits. I have been told that the injection well scenario in Lahaina is Patrick Wong. So he had the opportunity, from my understanding, to settle at a lower sum of money. That money would have just gone to fixing the problem. It would have been okay. He chose to appeal. I understand that cost the county hundreds of thousands of dollars. I can't find an exact amount. No. In legal fees, outside legal fees, right? A couple $100,000 of outside legal fees in order to appeal it. And then in the meantime, the fine has racked up to $100 million.
And it's still continuing every day. So, yeah, I think that by itself, I mean, if we have really clear points like the injection will, the moratorium, and our opposition.
And it's not like they didn't know, because all this was in the community that was hired to consult with them. And she told them, she warned them that exactly if they did what they ended up doing, this was what was going to happen. And they ignored her.
Yeah, so I think, do you have a quick question?
Can you briefly reiterate what he's being appointed for?
He's being reappointed as Corporation Counsel, and right now he's the lead attorney for the county. So all of these decisions or failure to properly defend the county is passing under his authority. He's saying, okay, we're going to do this. And so we think that we should be able to hold him responsible as well, since he's being funded with public money. And I think that about wraps it up. Thank you so much.
If there are more questions, we're going to be around, because this is really important that you have a chance to ask the questions you have. So we'll be around after. Don't leave if you have a question without getting answered.
He's an elected official?
Tomorrow's confirmation. They don't confirm him, the mayor's got to appoint somebody else.
So we're hoping to send this back to committee.
If we build a strong enough case, we could expect it to go back to committee. But outside opinion is that we're going to have to broaden that a little bit beyond just the moratorium in order to get through to the council.
Was he responsible for the hatchet job on the ballot language?
The Corporation Council was responsible for the hatchet job on the ballot.
They didn't agree, and they said that was miswritten.
Right. So they basically referred to it as a prohibition rather than a moratorium. So that's another thing. He changed the language on our initiative. He's not very good at it.
So I want to, first and foremost, can we just give a big mahalo to these three ladies? It takes a lot of work. Everything that you're doing takes a ton of work. And I think these women took it on their own behalf to aggregate and distill really important information that's going to take this movement to the next level. And so thank you for your time and all the energy you put into this. I also just want to take the opportunity to thank the attorneys one last time. So mahalo, guys. That it is the Shaka Movement that is funding this really important litigation, and that they need your support to continue that litigation forward. And so I think it's incredibly important that as a community, we pool our resources in whatever way possible and support the defense of something everybody spent their free time working to pass. So if we could just thank the Shaka group one last time.
There's a donate button on the GMO Moratorium news site.
Maui GMO Moratorium News.org.
Okay, this is where you send, again, officially, legally, you're supposed to have your testimony in about Patrick Wong by noon today, but it can't hurt. If you guys go home and send testimony today to the General Counsel, which is at this email address, about the appointment of Patrick Wong as Corporation Counsel, if you do it tonight, that'll be the first thing they see when they, thank you, when they go into work.
The opposing county communication 15-5.
Okay, and last question.
County, what time does testimony start? We want to be there at 7:15 to welcome them, because this is the county council starting this year's work, right?
The sign up list will start. The sign up list will stop usually at 8:30, and then the meeting starts at 9. They have some ceremonies initially, and then they go into public testimony after that, probably beginning around 9:15.
Until what time? Until noon.
And then thing of business about his reappointment.
What time is his reappointment?
The reappointment is not the issue. All testimony, public testimony is at the beginning of the meeting. They will then go through a very long agenda. After one of those items on the agenda will be Pat Wong, and also the water director, and many others.
Many other issues.
Testimony is at the beginning.
This is the beginning.
Yeah, and the earlier you get there and sign your name up, the earlier you're done.
And so as a final plug, we are really committed to continuing these practical teach-ins to help empower you guys to be better participants in this process. So if you like tonight and you think this is a good concept, please come see me. We're dedicated to doing this and kind of leveraging your community expertise and giving everybody a stage so that we can do better. So with that, thank you very much for coming, and we will see you again soon.
So just before we close out, just again, I'd like to reiterate on behalf of Hawaiian Studies, this campus here, I really appreciate faculty, students that are here, the whole community here, and it's part of our duty as a community college here, of course, to be part of the community, make sure that, again, education is the key for all of us. I hope to see everybody tomorrow. And we also, Hawaiian Studies, generally put on a lot of different talks and events on campus here, and I know I see some faces that come out all the time. And so, on behalf of the Hawaiian community, speaking on behalf of the Hawaiian community, this is one of many issues that we face as an occupied people. And if you're unsure about what I just said, perhaps you need to come and learn a little about the history of this place, and you understand perhaps that this is just one of the many issues that our people face and struggle with every day. Yeah? But I'm very happy and very proud to work with people like Ashley, Courtney's out there, and others that I've worked with in the past. As we understand, and I keep on saying, if this place will remain the Hawaii that I want it to be, It's going to take all of us working together. And that's the only way we can provide for a better future, for the land and the water and the future generations. So I'm happy and I'm very proud that, in fact, too bad we didn't have a larger room. But maybe next time we'll have twice as much people. Because I do know this. Power belongs to the people.
Amen.
If we show up with 100 people, not bad. You get 500 people in a county building, you start to worry. When we get 1,000 people in a county building, we will have reclaimed the power. It's just our house. It's our government. So, how do I get that? Correct. And the exact date is February 28th. We'll start at Lahaina, Malulele Park. Midnight will be a 1-week march around the island. And there's many issues tied in, but it's really unification of all the peoples. Yeah, didn't really make concern about the Hawaiian situation, but then again, all are welcome. And in fact, this issue again, what protects the land protects all of us. So, mahalo, Ortiz,